Good evening. I'm Bree Mobius, and I'm the president of the Sacramento Chapter of the Federal Bar Association. On behalf of the Eastern District Historical Society and the Sacramento Chapter of the Federal Bar Association, it is my privilege to welcome you tonight to our panel discussion on the trial, investigation, and aftermath of Unabomber Theodore Kaczynski. This panel discussion is the second in our series of significant cases from the Eastern District of California. Our first installment last year covered the trial of Lynette Squeaky Frome. We are fortunate again this year to have Judge Shubb return to moderate our panel. Judge Shubb is a senior district judge from the Eastern District of California, and he also served as the chief judge at the time of the Unabomber trial. Judge Shubb is also the founder of the Eastern District Historical Society. It is now my privilege to turn the proceedings over to Judge Shubb.
Thank you, Bree. It was in May of 1978 when a professor at the University of Illinois in Chicago found a mysterious package in the parking lot. When a campus policeman attempted to open the package, it exploded, injuring the officer. This was just the first of 16 bombs delivered over a span of the next 17 years to individuals in various locations across the United States. All but 2 of them caused serious injuries. 3 resulted in death. Law enforcement shortly came to the conclusion that the bombs were all being sent by the same person, whom they dubbed the Unabomber. Understandably, the public was struck with fear, not knowing when or where the Unabomber would strike next. The investigation came to a head in 1995 when the Unabomber sent a 35,000-word essay to the New York Times, the New York Post, Penthouse Magazine, and other publications, containing his so-called manifesto and offering to cease his bombings if they would publish it. With the approval of law enforcement, the Times and the Post published the manifesto. And when David Kaczynski read the contents of it, he began to think the unthinkable, that it was written by his brother, Ted. Working with the information provided by David Kaczynski, law enforcement was able to obtain a search warrant for a cabin occupied by Ted Kaczynski in an authorized area near Lincoln, Montana. With what they found in that search, law enforcement had enough to arrest Ted Kaczynski, and the decision was made by the United States Department of Justice to bring the prosecution here in the Eastern District of California. The decision was also made to ask for the death penalty. The defendant was indicted in April of 1996, and the trial began in the courtroom of United States District Judge Garland E. Burrell, Jr. in late 1997. After a lengthy jury selection process, in January of 1998, the defendant suddenly agreed to plead guilty in exchange for a sentence of life in prison without parole. In our panel discussion here this evening, we hope to discuss, among other things, how the FBI managed the investigation of such serious crimes, extending over such a lengthy period of time and such a vast geographical area. We'll also discuss the effect that those crimes had on their victims, one in particular. We'll talk about why and how the decision was made to allow the publication of the Unabomber's manifesto. We also hope to discuss what was involved in seeking and obtaining the search warrant, and how the decision was made to bring the prosecution here in the Eastern District of California. We hope to learn about the prosecution strategy, including the decision to seek the death penalty. We'll also learn the defense strategy. Finally, how the agreement was ultimately reached for the defendant to plead guilty in exchange for a life sentence. We have a distinguished panel with us this evening to discuss these subjects. Their full resumes are found in your program. First, to my immediate left, Terry Turchie was a special agent for the FBI for 35 years. Between 1994 and 1998, he was the assistant special agent in charge of the Unabomb Task Force. He's co-author of 4 books, One of them is entitled Hunting the American Terrorist, the FBI's War on Homegrown Terror. And the most recent one, which has the most relevance to this discussion, is entitled Unabomber, How the FBI Broke Its Own Rules to Capture the Terrorist Ted Kaczynski. Our next panelist, to his left, is Gary Wright. He was a computer store operator in Salt Lake City and was the victim, he prefers to say survivor, of the Unabomber's 12th bomb attack on February 20th, 1987. He has since developed a friendship with the defendant's brother, David Kaczynski. To his left, Judge Robert Stephen Lapham is a California Superior Court judge, presently presiding over juvenile court proceedings in Sacramento. He was an assistant United States attorney for the Eastern District of California, handling several high-profile cases in Sacramento between 1984 and 2013. And he was a member of the prosecution team in the Kaczynski case. Finally, to his left, Quin Denvir is a Sacramento attorney who served as the California State Public Defender from 1977 to 1984. And at the time of the Unabomber trial, he was the federal defender for this district and lead counsel on Ted Kaczynski's defense team. I would be remiss if I did not introduce one other individual who is present but not on the panel, the judge who presided over the Kaczynski proceedings, Judge Garland E. Burrell, Jr. Now, to get off the discussion, Terry, why don't you tell us how you got involved in the Unabomber investigation and how that came about?
Sure. Like most FBI agents for us, it was kind of a reluctant involvement. For myself, on April 1st of 1994, at about 12:35 p.m., and I could probably give you the seconds, down in the Palo Alto resident agency, where I was very, very happy, Judge, working national security cases, I received a call from our assistant special agent at the time of counterintelligence, Ed Appel. And he said, Terry, I just got off the phone with Jim Freeman. He was our special agent in charge at the time. And here's what I have to ask you. How would you like to come up to San Francisco and take over the Unabomb Task Force, which had been established a year earlier after the 1993 simultaneous bombings, both of those mailed from here in Sacramento to different parts of the coast. And I smiled to myself kind of. I said, well, that's a nice offer, Ed, and I'm good here. I love Palo Alto. I love being around Stanford, so I'm good. But thank you. And there was a pause, and he said, well, that wasn't a multiple choice question. So I'd like you to consider coming on up here as soon as you can. So I said, well, okay, how about a month? That'll give me time to kind of wrap everything up here, and we can find a new acting supervisor, and I'll head up to San Francisco. He said, how about in a couple of hours? And that's how many of us got into Unabomb. In fact, most of us, because of the length of this case, and I will use the words almost sheer hopelessness, and that's kind of how we thought about it. We all tried to avoid that corridor in the federal building in San Francisco that you walk down that housed the Unabomb Task Force. So that's how I got started.
Well, the investigation had been ongoing for a number of years. Can you summarize what the FBI had learned before you got involved?
I can. The investigation had, as the judge said, had gone on since May of 1978. And even though there were, up to this time, there were 14 bombings, there would be 2 more bombings while we were assembled as the UTF, or the latest iteration of the UTF. We didn't know a lot, but we knew certain factual details where we had questions, but we had no answers. And in looking back, particularly at the first 3 crimes, they became very important to us as we tried to look at a new way to put this case together. The first bombing, the one that happened in May of 1978, the main question was this. There was a package found at the University of Illinois Chicago Circle campus out in the Scientific and Technology Building parking lot. It had $10 in uncanceled stamps. And somebody went to pick it up and eventually got it to the police, and it was harmlessly exploded. But we never were able to answer that question all of those years of why do we have a package that had a return address of Northwestern University in Chicago, an actual addressee, and then $10 in uncanceled stamps. Why wasn't this package mailed? So that was one of the things we needed to focus on. By a year later, May of 1979, another bomb was found, only this time it was found inside Northwestern University. That struck us as very interesting because first bomb we had a return address of Northwestern. Now we have a bomb actually at Northwestern. And so we thought a lot about that, and we again tried to look at what possibly could be a connection between those two bombs. And then the third bombing in November of 1979, which got everyone's attention, a bomb was placed on American Airlines Flight 444 headed out of Chicago O'Hare Airport, headed for Washington National. There was a bomb placed on the plane via the mail that had been built with a barometer and fashioned as an altimeter, and it was to go off at a certain altitude. And when it did go off, because it was under a lot of cargo and luggage in the cargo hold, it started a fire rather than actually exploded as it was supposed to be. By the time this plane did an emergency landing at Dulles Airport, and the pilots were able to get down and take a look at the damage when the fire was out, they were prepared to say that years later that had this fire burned just a couple more inches closer to the main hydraulic line, this plane would have crashed. There would have been nothing we could have done to stop it. So at that point, the FBI lab expert, Chris Ronay, looked at this bomb and the parts and thought, it's very strange that we haven't seen any other bombs built by someone who would do this. So he sent out a bulletin and an alert to all kinds of agencies, and he got a call from the ATF. And they referenced the first two bombings in 1978 and 1979, brought all this together, and then we realized in November of 1979, we now have a serial bombing case.
How did the name Unabomber or Unabomb get coined?
The first two bombings were at or involved universities, Northwestern University and RPI up in Troy, New York. The first bomb with the return address of Northwestern, the second bomb in the graduate student room in May 1979 at Northwestern gave us universities as targets. By the time that this bomb was placed on the American Airlines flight, we now have universities and airlines. So this became, as you know, the FBI likes to attach these fancy names to its cases, mostly to get public attention, and this certainly did. Universities and airline bombings, Unabomb.
We have a chart behind us of all of the bombings. Without getting into all of the details, what was the sequence of events after the first three?
After the first three bombings, we would eventually have 13 more bombings for a total of 16, as the judge earlier mentioned. In 1980, the airline aspect of this got another boost. Percy Wood, the president of United Airlines in his Lake Forest home, Lake Forest, Illinois, received a package in the mail. But about a week before he received the package, he received a letter. And the letter was written to him by someone named, who signed the letter, Enoch Fisher. And in this letter, he said, you're going to be getting in the mail a package for me, a present. And you don't know me, but anybody like you, president of United Airlines, who makes decisions affecting the public welfare needs to read the book that I'm sending you. And the book turned out to be a novel that was written at the time. Even the author, Sloan Wilson, really said, I don't really have any social significance to my book, so I don't really know what they're talking about. I just kind of came up with it one day. But Percy Wood actually received that package that next week. When he went to open it, the book had been carved out and there was a bomb built into the book. And he suffered significant injuries when he opened this book in his house. So that was the fourth event. And all of those had a nexus to Chicago. Then no more nexus to Chicago. We're done with Chicago, and by 1981, we move on to Salt Lake City. In 1981, a bomb was left in a hallway at the University of Utah Business Building. Exploded in the bathroom harmlessly because somebody had noticed it and the police took it in there and detonated it. But we weren't able to do much with that. Just a few months later, we had yet another bombing. This bomb was mailed from Brigham Young University and ended up with a professor at Vanderbilt University in Tennessee. After that, the next bomb, 1982, was at Corey Hall at the University of California at Berkeley. That became a very important bombing. The victim there, the person who fortunately was able to survive his injuries, had gone into another graduate student room on the 4th floor of the University of California at Berkeley at Corey Hall. And when you go and you visit that and you look at that area, you realize, or it hits you, that someone who came up here and had the presence of mind and was not anxious about coming to this location on the 4th floor to leave this bomb here, very similar to what happened at Northwestern with bombing number 2. So that really made us start to think about that. And then no more bombs between 1982 and 1985. We then sadly started calling 1985 the year of the Unabomber. There were 4 bombs in 1985. One was at Boeing Corporation, addressed to the Boeing Fabrication Division in Seattle, Washington. All of the evidence from that bombing, gone, never to be seen again, because it was detonated harmlessly in a kind of a tar pit up there, and so we could never get anything back from that bombing. After that, another bombing at Corey Hall at the University of California at Berkeley, this time on the, as you walk in off the street on the street level and then go down a very, very narrow corridor that was occupied by graduate students. Again, just like the bombing in 1979 at Northwestern. By the fall of 1979, we have a bomb going to Professor James McConnell. Again, another come on to Professor McConnell, which I'll describe a little bit more in a minute. And then finally, in December of 1985, the Unabomber had his first, as he called it later, success with one of his bombs. And that was right here in Sacramento, California, out here at the old Century Plaza strip mall, a place called Rentec Computer Store. A gentleman there named Hugh Scruton, who was the owner of that store, came out from the door into the back parking lot one day around noon, and he saw on the ground, lying by a car, what appeared to be a road hazard, I'm sure in his mind. It was kind of a combination of Douglas fir and 2x4s and redwood 2x4s nailed together. Out of the 2x4s and Douglas fir, there was nails protruding. And unbeknownst to him, inside these pieces of wood, the bomber had carved into the insides and built a bomb. And when Mr. Scruton went over to move this so it wouldn't cause problems for any harmless passerby, as soon as he reached over to kind of break the contact between that device and the ground, it was a passive device, and it exploded. And it killed Mr. Scruton almost instantly on that morning.
The next bomb, I believe, was in Salt Lake City, and that involved our next panelist, Gary Wright. Gary, why don't you tell us what happened?
Sure. So yeah, just really similar to what Terry was just saying with the structure of the bomb. So 1987, I owned a computer company in Salt Lake City. My family worked there with me. I'd been out on calls, just working from about 6 in the morning, got back to the office around 10:30, and pulled into the rear parking lot of our building. At that time, I owned the building. And as I pulled into the parking lot, I looked down, and next to my secretary's car, so I had pulled in next to hers, there was a piece of wood. It was kind of similar like you say, but different. It was 2 2x4s put together and had 4 nails sticking out of it. Those 4 nails have always stuck in my mind because I can always remember one in particular. It was up on the right-hand corner, and it was bent just a little bit. But they were also the shiniest nails I'd ever seen. They looked like chrome, like something handmade, if you will. But I walked out of my car, went over, thought, same thing. There's something in the road. I need to get rid of it. Somebody will run over it, step on it, whatever. But when I went over and went to pick it up, there was something really quite wrong. I mean, there was an immediate feeling of huge pressure, and the sound of like a jet fighter going over, so like a screaming sound, if you will. And instantly, I'd moved a long way. I didn't know how I got there, but I realized I was jumping up and down like I was on a pogo stick, and I was hollering for my family. Everyone worked for me: my mom, my dad, my brothers. And they came out the back of the door, but as I'm jumping around back there, the only way I can describe the next thing I saw was kind of like the Matrix. So everything went into slow motion, if you will. You hear this at times, and I can tell you it's true. But I was looking at the power and the telephone lines that went into the building, and they were moving in a slow sine wave, very slowly moving. And I was watching pieces of things drift down around me, and there was a piece of red tape just kind of spinning around and like confetti. And I'm thinking, God, man, this is the weirdest thing I've ever seen. I'm going, what happened? And at that second, though, I really thought, well, I'm not going to make it. I thought somebody had come around the corner of the building and shot me with a shotgun for some reason. My family came out at that point, and I could see my dad was trying to say something to me. I was reading his lips pretty much because it was like being underwater in a swimming pool. You could kind of hear, but not really hear. And so he had been a state trooper in Salt Lake and had seen lots of things, and I could tell he was pretty upset. I'm going, well, okay, Dad's upset. Maybe this is bad. So slowly, he and my brothers, they took me over, sat me on the edge of the tailgate of one of the trucks, and sat there for a few minutes, and I started to get, I knew it was shock coming at that point. But while I was sitting there, I looked down, and I was dressed really nicely, had a dress shirt on, and I saw that my pants were gone from about the knees down. I had on a white dress shirt, and there was these things I couldn't figure out what they were in the beginning. They were just like threaded through my shirt like needles. I thought, what the heck? And I kept trying to put my head down to look, but I was running into trouble. What it was when the bomb exploded, it was inside of 2x4s that had been hollowed out, but it was all the slivers. So they had come up and impaled themselves. And the doctor later told me, he said, yeah, you look like a porcupine. I said, well, okay. That's something where they say life changes in a minute, but it's really life changes in a millisecond. You just never know. We walked into the building. I laid down. I got really calm and took everything off I had, gave it to my mom, and just laid there. And I guess I really realized it was pretty serious, because the next thing I see coming through the back door, so you think maybe a police officer, but it's like 25 police officers, and then when the ambulance crew comes in, there's 5 of them, and I don't know how you fit 5 guys into an ambulance, but they were pretty successful. And excuse me, I said, well, this might be worse than I thought. And I guess the real moral of the story of all of this is, it's not really fun when they cut your clothes off and your mom's sitting there. It's probably the most humbling thing you're going to run into. So I said, Mom, can you just please leave? This is not so good right now. But ultimately that day they took me up to the hospital. I waited about, I got there at 10:30 at the hospital, pretty close, and they started surgery at 6 p.m. Had no painkillers or anything till that point, and I can tell you the body's natural morphine's a pretty amazing thing. If you get hit, it really doesn't hurt. So that was a good thing for me to know. I went through 3 surgeries. The first night they basically went in and found that I had severed a nerve in my left arm. When the bomb exploded, it was moving very rapidly. And when some of that metal came apart, it was actually liquefied. And when it went into my arm, it actually cauterized the artery, so I didn't bleed. It just went in there and the metal was there. So I was pretty lucky in that regard. So that night they did a bunch of the face stuff, took out about 200 pieces of shrapnel from my legs and things like that. That was on a Friday the 20th of February. I went home Sunday. I didn't want to be in the hospital anymore and decided to recover a little bit at home. 2 weeks later, I went back into the hospital for another surgery to try and graft the nerve in my left arm back together. And they had to, ultimately, if you have a funny bone, we all do, right? They had to take it out and move it to the top of my arm. And I tell people now, I said, there's things that don't work, but I'm probably the fastest 9-fingered typist you're going to know. So, I'm good with that. Finally, a surgery later, had to transfer tendons and things in my hand, and it was really strange when the doctor got in there. Most people have 2 tendons in their thumb. I actually had 3, and it was funny because I needed to graft one into my index finger. So kind of lucky, weird, strange. Don't know why those things happen, but that's a morning that probably changes your family's lives in ways you don't know.
Terry, how much time passed between the bombing that killed Hugh Scruton that you've described and the bombing that Gary's just described?
Well, we had 6 years go by.
No, 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 between the time of the bombing before his and Gary's. 6 years in between those?
Run that by me again.
How much time between the bombing that killed Hugh Scruton and the bombing that Gary's just described?
Okay, the bombing that killed Hugh Scruton was in 1985, and Gary's bombing was in 1987. So we had about a year and a half, 18
All right.
months.
Now, how much time between the bombing that Gary's just described and the next bombing?
And there we had 6 years, 1993.
Now, do you have a theory as to why there was so much more time after this one than there was before?
The topic of why did we have all this time was widely debated, and then when we finally had the right guy and found a number of Theodore Kaczynski's writings, we found that during that time he was actually experimenting to build smaller, more compact bombs and more lethal bombs. And that's why when we start talking about the latter series of these bombings, instead of boxes and packages and 2x4s, you literally had something the size of a video cassette that was placed in the mail to the future victims.
In other words, he had one death and the next one was a failure.
That's right.
It did not kill Gary.
right.
Do you have any theory as to why Gary was not killed in that bombing?
Well, Gary and I have actually talked about that. First of all, there's just a lot of gratefulness there that it worked out that way, but I think some of it is the way that Gary actually approached that bomb.
Yeah.
We feel that Mr. Scruton walked over, as any of us would probably do, to pick up wood from your best vantage point, to pick it up and get the weight and get it out of the way. Gary, when he walked, and then he took that full brunt of that explosion. When Gary walked up, you kind of had the, as you've told me, the inclination to kind of reach to the edge, and you
Yeah.
kind of moved it. And so when you moved it slightly, it exploded, and the force went in a different direction rather than had he picked it up in a different way.
The final two bombs did result in death, is that right?
They did. The last two bombs, 15 and 16, Thomas Moser was an advertising executive in Caldwell, New Jersey. He got one of those bombs in the mail. It was just a week or two before Christmas, and the kids, he had little kids running around the kitchen. They were getting ready to go get a Christmas tree. And their mom called them almost at the last minute. Mr. Moser had been out of town, had been over in London. And so the kids went off to get their pajamas off and get ready to go. And there was a lot of mail that had stacked up. So he started going through the mail. And the first thing he took was this package that had a San Francisco return address on it. And his wife heard this terrible, terrible noise. And by the time she got down towards the kitchen, there was smoke everywhere. And this bomb was so powerful in this video cassette type of container that, and it had shrapnel just as Gary's bomb did. But when it went off, they had those copper skillets above the stove hanging on a rack. And it actually went through, some of this shrapnel went through some of those really thick skillets. That was the power of this blast. And Mr. Moser was killed as well, almost instantly, just as Mr. Scruton had been in 1985. Finally, in April 24th of 1995, again, right here in Sacramento, at the California Forestry Association, a bomb had been sent in the mail, actually addressed to Mr. William Dennison, who was the president of the CFA. But he'd left, and he had been replaced by Mr. Gilbert Murray. And Mr. Murray was going to, I guess, take this package up to Mr. Dennison up in Northern California, but went ahead to open it to see what was in it, since it was addressed to the CFA as well. And again, the same kind of bomb that Mr. Moser received, with all the power and all the destructive power, and just had no chance as he was sitting at his desk and opened that package.
Can you talk a little bit about what the Unabomber was doing to avoid detection?
I can. At the time, of course, we realized we were after somebody that knew a lot and was certainly too smart to leave a trail for himself. We had no idea how smart he was. Turns out Theodore Kaczynski was a genius, but he went to a great deal of work and effort to make sure he didn't leave a trail behind. For example, all these bombs, they were all handmade. Gary mentioned seeing something shiny that looked like maybe a chrome nail. Probably was something that was fashioned from chrome on an old junked car up in back of Kaczynski's cabin. He would start with the bombs, and he would build them all from scratch. So normally when we try to trace things back from a bombing crime scene forensically, in this case, we couldn't trace many of these things back to anything. He would take casings off of batteries, so you couldn't go back to the batch number or find out where a battery had been bought or something like that. So it started with his bombs. He took sandpaper and sanded all of his devices very, very carefully to make sure that when those bombs were placed in the mail, they didn't have any of his fingerprints on them. He wore gloves when he was carefully putting these bombs together. In one instance, he actually went to the men's room at the bus station in Missoula, Montana. He got down on the floor and he gathered hair from the floor of the bathroom. And he took that hair back and then he started putting it in between layers of tape on some of the future bombs he built. He would later write that I did this because if the FBI found hair at a crime scene, they would think the hair came from the person who built the bomb. But really, it was just something I found at the bathroom. When he would go out to buy things like old pieces of pipe or anything he might use to create a bomb, he would disguise himself. In one instance, he reports or talks about when he's writing, going to a junk store in Salt Lake City. And he had stuffed his nose with cotton, and he had trimmed his hair, he had dyed it black, and then he had on these really weird glasses that he'd put on. And he went in there and he figured, hey, if anybody sees me, they're certainly not going to recognize me the way I look today. And he did all these things in an effort to make sure he concealed his identity and helped him later if we started looking at him seriously as a suspect.
There was a famous composite picture of the Unabomber that was circulated, and everybody was familiar with that. How did that come about?
Well, Gary was part of a major turning point in what we call Unabomb history, and that is on February 20th, 1987, you all saw the Unabomber. Tammy Fleury, who worked inside cams, was literally looking out the window 4 feet from where he was kneeling on the ground to arm the bomb that you would eventually come across. And she noticed right away something was wrong. And so she's calling your dad, calling Mr. Wright, and she's watching all this. She's watching literally Theodore Kaczynski set this bomb in motion for when somebody walks along. And then her attention is taken off of him, and then he leaves. He walks around the corner of the building, he's gone, and then almost immediately you just happen to pull in at that point. But she described him, and this was the first time we knew that the Unabomber could say for sure, it really appears the Unabomber certainly is a male, because we kept getting that question. I mean, are you sure it's a male? And you're sure it's one person and all these kinds of things. But she described him very, very well, and this becomes also one of the more embarrassing parts of this case for us. This, of course, happened in 1987, and she described this man perfectly, and subsequently a composite was put together. And that composite was distributed between 1987 and the time of our task force in 1994. But Tammy was never happy with that composite. And so something dramatic had happened here in the Bay Area during that time frame. You're familiar with the case of Richard Allen Davis and the kidnapping and murder of Polly Klaas. Well, if you've seen the picture of the actual photograph of Richard Allen Davis, and you've seen a composite put together by Jeannie Boylan, who was an artist, a police artist, after the fact, you see the similarity in these two, the composite and the photograph. So we started thinking as we were looking for different ideas and different things to apply to Unabomb, why don't we go back and redo the composite, and why don't we use Jeannie Boylan? And so Max Knoll, who was one of our case agents and supervisors on Unabomb, actually got on the plane and flew out and met Tammy, and her young daughter was there. And Jeannie Boylan was going to sit down with Tammy and go through the painstaking detail of putting together this new composite that we ultimately distributed. And Max likes to make sure people know that you think that an FBI agent doing something like this has a really glamorous life. While Jeannie Boylan and Tamara Fleury were in the other room doing the composite, Max was trying to entertain the kids and watch multiple showings of The Lion King to keep them really busy. But it turned out that composite, the gray hooded sweatshirt, the aviator sunglasses, we got that out in 1994. And we put it out with a message. By this time, we were also telling the public, think of Unabomb and think of 4 devices in the 1978 to 1980 period in the Chicago area. Then think of the middle of between 1981 and 1982 in Salt Lake City, think of 2 bombings at Corey Hall in Berkeley, and from about 82 on, think of a nexus with the Bay Area. And look at this composite. Those are the things we were dealing with as we were trying to bring the public into this big mystery. And we had one other small detail. The original composite, because you can't think of everything and please everybody all the time. The original composite, the artist's mother got really mad that we pulled that and put out a new one. So we got a number of calls that she was very, very upset and very disappointed that we would do that. So you never know what you're going to get on the next phone call, but those are some of the things that happened along the way.
The real break came when you received the manifesto. Can you tell us about that?
We wanted the piece that would bring all this together, and we would have pulled out most of our hair to do it. In fact, I think I did. And finally, the Unabomber, after the murder of Mr. Murray, we also keep in mind April 24th, 1995, just days earlier, we'd had the bombing of the Murrah Federal Building in Oklahoma. So all of this is on the news, and what do we get? We get letters flooding out from the Unabomber to the New York Times, Penthouse, all kinds of different places, the Washington Post, and to us indirectly, that the Unabomb group, which he called the terrorist organization FC, is preparing a manifesto. And they want that manifesto to be published, and we'll eventually get a copy if we agree to their terms. And so the idea was that the New York Times would publish the manifesto, possibly the Washington Post. But if they didn't publish this manifesto, that again, we hadn't seen yet in April of '95, we would end up seeing more bombings. And yet if they published it, the terrorist group FC would desist from any more bombings. So in September of 1995, we actually get 2 things happening. One is the San Francisco Chronicle gets a letter one afternoon saying, this is the terrorist group FC, I put a bomb on an airliner out of LAX. Of course, that spun us all up, and everybody's command post is lit up everywhere, and we're trying to figure out how to deal with this. The next day, the manifesto starts flooding into these various places. 7 people got copies of it, and it was accompanied by a short letter that said, hey, just one last joke from the terrorist group FC. Here's the manifesto. And so once we got it and started reading it, and we had our profiler, Kathleen Puckett, really dive into this, it did 2 good things. One is it really, for some of us, seemed to be the piece that could really bring this all together. For many people, they thought it might be a red herring, that this has no relevance to this case at all. So we had to decide how we were going to deal with it and how we were going to fit it into this, but we also had to decide something else, and this became our biggest decision. What kind of recommendation are we going to make to the Attorney General, Janet Reno, and to the FBI Director, Louis Freeh? Because essentially what we're doing here, no matter what way we go, if we decide to recommend that you publish or that the Post and the Times publish the manifesto, the big thing was, are we giving in to terrorism? Are we basically involved in an extortionate transaction with a terrorist? And isn't it against U.S. government policy to negotiate with terrorists and to give in to extortion? That was the big issue that kind of permeated our entire thinking between the time we got the manifesto in September, or in April, and the time that it was published in September.
And ultimately, you decided that it would be published.
Yes, we did.
What considerations went into that?
Well, we threw this around, and we came to a conclusion, and there were about 6 of us: Jim Freeman, the special agent in charge of the San Francisco office; Max Knoll, who eventually would put together the arrest plan for the Unabomber; Kathy Puckett, who I'd mentioned, and myself. And we threw this around back and forth, and went into another room and decided, okay, our recommendation should be that we don't publish it, that we don't recommend publication. So we took off to write up how we were going to write this and present it to the Attorney General and FBI Director. And we all started looking at each other. We had Tony Molyat in there with us, who is actually a Sacramento resident, U.S. Postal Inspector, was on our task force. We all look at each other, and it's like quiet. We decide we made the wrong decision in there with the special agent in charge. So we had to go back in, or I had to go back in, and say, I've got some news here. We think we ought to change our mind. And so we had the discussion all over again. And for one primary reason, we felt that publication was the way to go. And that is, it was our missing piece. It was so detailed, 35,000 words, so passionate and so specific that we felt it represented the lifelong thinking of the person we were looking for. And that if we could take this piece now and put it with those two other pieces, the composite, the geographical kind of sequencing, and then read the manifesto, put it all together and call us if you know anyone like this. That's what we sold to the New York Times, the Washington Post, the AG, and the FBI director. That's what they decided to do. And the manifesto was published on September 19th, and between September 19th and April 3rd, or actually the middle of February of '96, we received over 55,000 phone calls on the Unabomb tip line. We had wives wanting to turn in their husbands. We had girlfriends gladly wanting to turn in their boyfriends. And yet none of those people were the Unabomber until that call in the middle of February from a fellow named David Bisegli. And Tony Bisegli in Washington, D.C., and he was representing, at the time, an unknown client. And they wanted to talk to us about some information that the client had.
Steve, you were in the U.S. Attorney's Office all this time.
I was.
When did you become involved in the Unabomber investigation?
I became involved in April of 1993, and I had just finished a fairly prominent arson trial with ATF, and I was very much associated with ATF at the time, doing a lot of their cases. And an agent named Greg Barnett brought me this case that had long been dormant. The Unabomber hadn't been heard from in about 6 years at that point, and he said, "Here, take a look at this." And so the reason he brought that to me was because there's typically a 5-year statute of limitations on all federal offenses. The statute, we had 12 bombings up to this point. The statute of limitations had run on all 12 of those bombs with the exception of one. There's no statute of limitations on capital murder cases. So Hugh Scruton was killed in Sacramento in 1995. That was the one case that was still subject to any kind of federal jurisdiction, and the venue was appropriate in Sacramento. So the bottom line was, it was the only place where the case could be investigated.
Did you start to work on the case at that time?
I actually did. It seemed an important enough case. There were some working theories, not very good working theories, about who the Unabomber might be, some of which had been developed by ATF agents in Chicago. I wasn't aware at this point that there was such a thing as the Unabomb Task Force. And so I dived into the case and started mastering the facts.
Did you eventually get involved with the task force?
Yes, it was actually very shortly after that, I'd say within 4 to 6 weeks after that, that I started attending task force meetings, and I think Terry may have a better, well, you weren't there at that point, but very shortly after that, June of 1993, we heard from the Unabomber again. He mailed 2 bombs from Sacramento. One went to a Yale University professor in New Haven, and the other one went to a professor at UC San Francisco in Tiburon. So now we're off and running again. We've now heard from the Unabomber again.
Were you on the task force at the time that the decision was made to publish the manifesto?
Yes.
Did you participate in that decision?
I don't recall. I mean, we informally, yes. The decision was made essentially by the FBI, but there were several discussions we had, and by we I mean Steve Ficero, an AUSA from the Northern District, was on the task force at the time, and we were, as I recall, I was certainly very strongly in favor of publishing, and I think Steve was also. It was basically a 35,000-word writing sample.
How did you learn about David Kaczynski and his involvement?
I think Terry or Max probably notified me that we had been contacted by an attorney, Tony Bisegli. And Terry, if I'm not mistaken, that occurred in the fall of
The contact was in
95.
February of 90, with Tony Bisegli was in February of 96.
That's when we put agents in Montana.
Right, it was just, it all happened very fast.
right.
It was February 15th when we first heard from him.
So it's interesting how you compress time, but, because I had remembered it as occurring earlier than that, but the bottom line is, we were contacted by Tony Bisegli, and he recounted how he had a client, he was representing the client anonymously at that point, who believed he knew who the Unabomber was. This client had hired a private investigator to check it out. The private investigator had come back with the conclusion that there was a 60% chance that Ted Kaczynski was the Unabomber. And with that information, David Kaczynski authorized Tony Bisegli to go to the Department of Justice, relate his information. And it came with a price. David Kaczynski was asking that in return for divulging who this individual was, he wanted the Department of Justice to forego seeking the death penalty.
Did they do that?
No, the Department of Justice rejected that offer.
But nevertheless, did you receive information from David Kaczynski?
Yes, he came forward, he gave us the information. And I think one of the reasons he did is if you look at some of the diaries and journals for Kaczynski, he had been estranged from David for quite some time. But he reached out to David uncharacteristically in I think initially in 1994, asked for a $1,000 loan. And David, being a compassionate person, of course, agreed instantly, sent Ted the money, thought Ted was probably in declining health, maybe he needed it for that. Later, Ted is back asking for another loan from David, this time $2,000. David once again gave the money. And then when David started feeling that his brother might be the Unabomber, he started connecting the dots and came to believe that his loans to his brother had actually financed the last two murders, bombs 15 and 16. And that actually turned out to be correct. And I think out of just that sheer knowledge, David understood that he couldn't sit on this information, and he divulged it.
Along with the other information he divulged, you learned where Ted Kaczynski was living?
Yes.
Now, how was the decision made to get a search warrant for that cabin?
We had had a search warrant in various stages of preparation all along because it was a massive search warrant. And there was a lot of information we could include in the warrant before we even knew who the Unabomber was. You have to put in information about each one of the 16 devices, including the various components of the devices so that you know what you're searching for when you execute the warrant. You have to put in the basic facts that connect all the 16 devices. So a lot of that was already done.
By your team? Who did that?
By various members of the team. Steve Ficero took the lead on that, and in the final preparation, when we knew who the warrant was going to be executed against, Steve Ficero, Max, Terry, and probably others, and a couple of 24-inch pizzas, spent an all-nighter drafting the final version of the warrant and faxed it off to District of Montana in the early morning hours.
So a judge in the District of Montana issued the warrant.
Correct.
And what did you learn when the warrant was executed?
Well, you're asking about the search?
Yes.
The results of the search? The search lasted over 9 days, and people wonder, why does it take 9 days to search a 10 by 12-foot cabin? The working assumption was that when we went into this place, it would be a bomb factory. And protocols were in place to x-ray everything in place before they're moved. And in fact, on day 2 of the search, we found a fully functional bomb under Ted Kaczynski's bed. And so that everything stopped at that point. We got a tractor, what do you call them?
We had a bomb disposal. We had a particular piece of equipment that had been designed by Sandia National Lab that was geared to Unabomb devices because Unabomb devices had multiple triggering devices. So this was ready and was flown up from Riverside, California, and deployed to bring the bomb out of the cabin.
So everything comes to a screeching halt at that point. The agents are cleared out of the cabin, and the bomb is removed. The search continues, and basically what we found are some broad categories of evidence, about 40,000 pages of Kaczynski's writings, which included admissions to almost all of his bombs, if not all. We found diary entries that explained his motivations for killing. We found experiment binders containing 240 experiments that Kaczynski had done over the years trying to perfect his bomb-making techniques. We found physical items in the cabin relating back to bombs, Unabomb bombs. In particular, there was a very specific signature piece of Kaczynski's bombs, which we call the flip switch. It was the mechanism that basically completes the electrical circuit, brings two pieces of metal together to complete the electrical circuit to detonate the bomb. Very unusual design characteristic of Unabomb devices. The flip switch itself was made of a piece of wood, hickory, I think, that was fashioned probably out of an axe handle or a hammer handle. We found an oatmeal canister that contained, I think, 17 of those flip switches. And they were virtually, you put them side by side, they're virtually identical to ones that we found in Unabomb devices. One of the most important pieces of evidence we found that we all said if we want anything in the world, this is the thing we want. A L.C. Smith Corona typewriter. Since 1982, the Unabomber had used an L.C. Smith Corona typewriter that the FBI lab estimated had been manufactured in 1934, 1935 with 2.54 spacing, which is the centimeters between the letters. We were looking for a very specific object. This is the typewriter that the Unabomber had used to not only type the manifesto, but to type everything from envelopes that accompanied his bombs to Terry talked about the letter that preceded the Percy Wood device. That letter was typed on this typewriter. If we found that typewriter, that would connect Kaczynski to all of the devices. We found one old typewriter in the cabin. Experts took a look at it, wasn't the one. Found a second one, not the one, according to the experts. On the last day of the search, we found in a ammo canister, ammo box, L.C. Smith Corona typewriter manufactured in approximately 1935 with 2.54 spacing. That was the typewriter.
So I take it with all the information you found, you had no doubt that you would be able to prove a case against Ted Kaczynski.
We felt that you could parse out the evidence 10 different ways and convict Ted 10 different times. It was not a case that we thought was lacking in proof.
The decision to prosecute in this district is interesting. Can you tell us how that came about and why the decision was ultimately made to prosecute the case here?
So I indicated previously that the statute of limitations is 5 years for most federal offenses. By the time we got to 1996, when the Unabomber is captured, we have a valid statute of limitations on only 5 devices. 3 murders, and then the devices in 1993 that were mailed from Sacramento that went to separate parts of the country. So as of 1996, Sacramento, the Eastern District of California, had venue over 4 of the 5 devices. 2 of them because the bombs had gone off here, 2 of them because the bombs had been mailed here. The only device that we didn't have venue over was the one that was sent from San Francisco to New Jersey. And that was separately indicted in New Jersey.
Who actually made the decision to prosecute here?
Attorney General Reno was the one who ultimately made the decision. We went back to Washington, D.C. and made a presentation to her. And by we, I mean Steve Ferchero was part of that discussion from San Francisco. I believe Bob Cleary from New Jersey, the first assistant from New Jersey, was there. And we basically laid out the case for her, the competing concerns, where the case should be prosecuted.
Was there any disagreement?
There wasn't. There was actually quite a bit of harmony here. It was an easy decision to make for the reasons I've stated. We had the choice of prosecuting the case in 2 locales or 4, with 4 of them being in 1 location. So it was really, from a lawyer's standpoint, a pretty easy decision to make.
How was the decision made whether to seek the death penalty?
That was made through the Department of Justice's normal operating protocols. There's a death penalty review committee that is convened in all cases where the U.S. Attorney wants to seek the death penalty. That committee is composed of high-level Department of Justice officials. The prosecution is required to submit a package to that death penalty committee setting forth all the information you would expect, the basic facts of the case, the aggravating and mitigating factors that would warrant seeking the death penalty, of course, the statutory basis for seeking the death penalty, such as the laying in wait or deliberation, planning, things like that. The defense is also invited to make their submission, stating whatever mitigating factors they believe. And in this particular case, David Kaczynski was invited to participate in the death penalty review committee.
And what position did he take?
Surprisingly, he was asking for his brother to be saved, spared the death penalty. His position, as I recall, was twofold. He basically said, look, in his view, these crimes had been motivated by his brother's mental illness and not by true criminal behavior. And he also made a pitch that if the Department of Justice sought the death penalty, the blood would really be on his hands, David's hands, because David had come forward, provided the information necessary to find his brother, and David felt a great deal of responsibility, as any brother would.
Quin Denvir, were you actually the federal defender for this district when Ted Kaczynski was arrested?
No, I had been selected, but had not yet taken the office.
And how did you learn that he had been arrested?
I'm sure I picked up the Sacramento Bee and read about it.
Now, did you take any steps to be appointed to represent him even though you were not actually the federal defender yet?
Yeah, I contacted the federal defender, Ruth and Beck, and told him that I would like to be appointed under the Criminal Justice Act to represent Ted since he had been arrested. Even though he had not been brought to this district, we didn't know whether he was coming to this district or not. And he approached the court, and I was appointed and took it up from there.
What were your thought processes in making the decision to ask to be appointed to represent him yourself?
Well, I felt that if the case did come to Sacramento, that the Federal Defender's Office should take the lead on it. There had been a case a couple years earlier, the Oklahoma City bombing, where the local office had deferred and had private attorneys handle the case. I had been a county public defender, the state public defender. I was now going to be the federal public defender. I kind of thought public defender offices should do the hardest cases, the biggest cases, and thought that our office should take care of it.
Did you go back to Montana to interview Ted Kaczynski?
There was an early meeting where, when it was unclear where this case would be brought, where the federal defender from San Francisco, the federal defender from New Jersey, federal defender up from Montana, and myself all met together there to kind of talk about where things might go and things of that nature. And we actually met with Ted at that point for a short time period.
Did you participate in the proceedings to determine whether the government would seek the death penalty?
We did. The question of whether the government would seek the death penalty was not decided at the time of the arrest or the time of when it was decided where it would be prosecuted. It was months beyond that. The Department of Justice allows the defense time to put together a case for mitigation, and we took advantage of that for some amount of time and went back and presented that case to this Capital Review Committee or whatever it was called. I should say that David Kaczynski made two other points why there should not be a death penalty. One was, he said, if you execute my brother after I was the one that brought him in, no one will ever bring anybody in again. And the second thing he said is that Steve is right, I guess, because I wasn't there, that when Tony Bisegli first approached the government about an agreement, no death penalty if David would cooperate, that was turned down. But David said that later he was told during the course of this, or somewhere in there, that it would be a good thing for there to be for Ted to be arrested and brought in, because he would not do other damage, which I think really worried David more than maybe guilt about he had helped on two earlier ones. He was afraid that he had information about who was doing this and the person might continue to do it. But he also was told something to the effect of, and it'll be better off for him. And he took that to mean that there would be some consideration. There was an agreement. So that he made a presentation, we made a presentation. All cases where the death penalty is even possible goes to that committee with a recommendation from the local U.S. attorney one way or another. This one, there's a recommendation for it. The committee recommended that Attorney General Reno approve the authorization of the death penalty, and that's what happened.
What steps did you take to put together a defense team after you learned the government was going to seek the death penalty?
Well, we put the defense team together as soon as we found out the case was coming here. I wanted people to be involved in this presentation of the mitigation to the Capital Review Committee. I knew we needed, I felt that in the office I was the one that was the most qualified to be the lead counsel, though I had not tried a capital case. I'd been involved in a number of capital cases in various roles. And I wanted to get another attorney to be, so we would have two of us working together. I felt again that we should look within the federal defender system for the second attorney. There wasn't a need to go out to, that we had the resources there. I had several, 3, 4, 6 months earlier, been at a death penalty conference down in Houston, and one of the people there was Judy Clark, who at that time was the federal defender for Eastern Washington and Idaho. And she'd taken part in this. I was quite impressed with what she said and everything. We later went out to the airport together. We had a couple of beers together. We flew to Denver together, and we didn't see each other again. And I knew she was very well thought of, both for her trial work and for her legal skills. And she had recently handled her first capital case. She had gone back on her own time, taking a leave of absence from her job, to co-counsel a case in South Carolina, I believe, or North Carolina, Susan Smith case, a woman who had driven a car into a lake and the children had died. She had done that with David Bruck, who's one of the best death penalty defense attorneys in the country. And so I knew she had that experience. I approached her. I knew she was a tireless worker, literally tireless. I'm not tireless. And so I approached her, and she said she'd be willing to do it.
Who else was on the team?
Well, we wanted we wanted an attorney to take over the role of developing the mitigation themes. In a normal case, a non-capital case, you have a trial where the only question is, did he do it and what did he do? And then it goes to a judge to hear evidence or something along those lines to make a decision as to what the sentence would be. In a capital case, you have a separate penalty phase where the same jury who decided guilt will then decide the penalty. Penalty here was going to be either the death penalty or life without possibility of release. That's actually the federal phrase, not parole. And what had developed over time in the capital defense community was the idea that the government is going to have the whole guilt phase focused on the offense, and they're going to prove the offense and who did it. And then you're going to shift over, and the jury's going to know all about that. Then you're going to shift over to the penalty phase, where the defense has to bring a focus on the offender, the person who's been convicted of the crime, and to present to the jury every possible theme, fact, prediction, hope, as a reason why they would say, we could let this person live and die in prison rather than being executed by the government. And there are a number of people who have worked in those areas, have a lot of experience in those areas, and one of them was a lawyer by the name of Gary Sowards, who was in San Francisco. He had formerly been with the California Appellate Project, and we asked him to come on as the mitigation attorney. Then there's also there are these specialized investigators who have a lot of experiences. I mean, we've had a lot of death penalty cases in this country. A lot of people learn a lot. And they become basically what we call mitigation specialists. They're really investigators who specialize in presenting these mitigation themes. First of all, searching everywhere about the person's background, everything you can, to then to find the themes that you can present to the jury. And one of the best, and probably the one who started that whole craft was a woman by the name of Charlotte Holdman. She also was in San Francisco, so we hired her, and then in order, they needed people then to go out to talk to everybody you ever knew Ted, go up to Lincoln, go to Harvard, go to Michigan, Berkeley, everything. Talk to everybody you can to find out more about the person that you can then present to the jury, so they'll see who this person is, not just the offender. Because one of the themes is, in these cases for the defense is, no one is the worst thing they've done. There's always more to it. And that's true of every person on the jury. It's true of everybody. You're never only the worst thing you've ever done. There's always more to it, and you want to show that here. And so we decided then to retain some college or law students who took time off, and they worked under Charlotte as being the kind of the people on the ground, going out and talking to everybody and writing reports.
Steve, you also had a team. Who was on your team?
Bob Cleary was the head of the team. He was the first assistant in New Jersey. Steve Ferchero had been on the Unabomb Task Force for quite some time at that point. He was from the Northern District of California, and then I represented the Eastern District. So basically, we had assistant U.S. attorneys from the 3 involved districts. We also had a very able prosecutor from Montana, Bernie Hubley, and an extremely able writer, an assistant U.S. attorney named Douglas Wilson, who came on to basically be our brief writer, because we knew this is a case that was going to involve a lot of briefing on a lot of different issues.
Wouldn't be brief.
Speaking of briefing, Quinn, it sounds like there was a lot of evidence obtained as a result of that search. Did you make any effort to quash that search for any reason?
We did. I mean, one of the jobs of a defense attorney is to look at search warrants and see whether you think that they are lawful, and if they're not, whether the evidence that's seized pursuant to the warrant can be suppressed. And we looked at that search warrant affidavit, actually about 100 pages, I recall, and the FBI was hustling to put that affidavit together with good reason, because they were afraid there might be another crime, and they compiled a lot of things, but we felt that in the end it wasn't sufficient. You have to understand that basically until David Kaczynski, through Tony Biseglia, contacted the FBI, no one in the government had ever heard of Ted Kaczynski. He was not on the radar. In fact, later on, they found his name in a big data bank of people who graduated from the University of Michigan. So when David then came in and said he thought his brother could be, and I don't think he ever said he was, but I think he thought he could be, he was really concerned about this for reasons that both Steve and I have explained, gave the information. Then the government put a lot of folks out working very hard to put together the search warrant. We felt that it didn't show probable cause to believe, the facts in there were not sufficient to show probable cause that Ted Kaczynski was a Unabomber. We filed a motion to suppress. Government responded, we replied. It went to Judge Burrell, and Judge Burrell felt that there was sufficient probable cause. I have to say two things about that. One is, I'm convinced to this day that if they'd gone into that cabin and found nothing about the Unabomber, but found a pound of marijuana and charged him with marijuana, we would have had the warrant thrown out. But there's something that just as a matter of reality, it's very, though I believe in the law, and I believe the law has got to go where it's got to go and where it's going to be driven, there is something that's very kind of counterintuitive to say that these facts don't show probable cause that he is the Unabomber when inside the cabin after the search, there's endless evidence that he was. I mean, it's just, I think that's kind of a head change that it'd be very hard to make.
Did you just argue that there was not probable cause, or did you present some evidence to the court to persuade the judge that there was not
Judge,
probable
we always
cause?
present evidence. We don't just in arguing, you know that.
Tell us about it.
No, we went through everything that was, every fact that was stated in there, other than the nature of the crimes, that they were linked together, which was irrelevant to the question about whether there's probable cause to believe Ted was there, and tried to show that it didn't have the significance that they attributed to it. And one of the big things that was done, there was a substantial part of the affidavit was devoted to the Unabomber manifesto. And there was a detailed analysis of it, trying to show that words in there and concepts in there could be attributed to Ted Kaczynski. And we went through and tried to show why that was not true. One of the most striking, I think, was the Unabomb manifesto said, you can't, I always get this wrong, you can't have your cake and eat it too. No,
you
it's the
can't
other way
eat your
around.
cake and have it too.
No, we always say, the normal way we say is you can't eat your cake and have it too. That's the
No.
normal one, right?
No. No.
Ted Kaczynski has you convinced.
No, I'm trying to remember what the phraseology. You can't eat your cake and have it too. You can have your cake and eat it too. You got it backwards. And the interesting thing is, and we hired a linguist to go through and look at everything that was in there. But one of the things interesting about that is the phrase "you can't have your cake and eat it too," which is really literally correct. You know, you can't have your cake and eat it too. Is the correct one. It also goes back to the Bible from the book of Proverbs, and it's been used in literature and a number of different places. So it was not some unusual phrase that only Ted Kaczynski ever used. Though the affidavit did point out he had used that phrase in a letter to his mother, so it was not foreign to him. But it wasn't like this curious phrase that gee, he's the only guy who's ever said that. He must have done this. And then we went through all the rest of it. They made a big point of the fact that the manifesto spelled installment with one L instead of two L's, and our linguist said that's a very common thing. The number of times certain words were used, the linguist said that didn't mean anything if you looked at it. And then we point out things that cut the other way. For instance, as I recall, Ted split his infinitives and the manifesto didn't, or vice versa. So we put on a lot of that, and then there were there's a lot of facts collected about his movements, and we tried to explain that none of them ever were linked to any particular of the bombs. But you have 100 pages, of which probably 80 pages are facts that are supposed to show the probable cause, and we try to take those on across the board.
Given the court's ruling denying your motion to suppress. What was your trial strategy?
Well, I mean, it was clear that if we didn't win the motion to suppress and the evidence from the cabin came in, that there would be a guilty verdict. I mean, Steve's giving you a little bit of what that what it was. I mean, Ted had written thousands of pages of journals, and he discussed this. There were, all the stuff that Steve's talked about. So it was clear that he was going to be convicted. The only question then was, what would the penalty be, and would it be life or death, basically? And so our goal from then on was to, having lost the suppression motion that might have changed the whole guilt question. In fact, I would have eliminated a guilt trial because there wasn't enough evidence without that. Then we had to start dealing with the question of what the penalty would be when the jury did convict him.
Steve, what was your trial strategy?
To win. We knew, that there were two cases going on at this time that was catching national prominence, the Oklahoma City bombing case and ours. And I kind of viewed those as the flip side of the coin. In Oklahoma City, I thought they might have a difficult time proving guilt, but once they prove that, who's not going to give the death penalty to someone who's killed 368 Americans? I viewed ours as the evidence was overwhelming. I had very little doubt that we were going to get a conviction, but we knew that a mental defense was coming, or probably would be coming, and that was going to be the battleground.
So what did you do to protect against that?
Well, we prepared to meet the defense, whether it came in the guilt phase or the penalty phase. We had amassed a lot of evidence with respect to Kaczynski's desire to kill, when that was formed, his lack of remorse, his struggling with his conscience as to whether or not killing was an appropriate way to go. And we felt that he was his own worst enemy. He had written so much on those subjects that we were just going to display that for the jury.
Did you make any effort to get a mental examination of Ted Kaczynski?
Well, we did. That came up because the defense in June of 1997, the trial commenced in November of 97. In June of 97, the defense filed a motion setting forth their intention to put forth a mental defense, short of insanity. That triggers certain rights on behalf of the prosecution. We can seek to have our experts then do a psychiatric examination of the defendant.
Did you ever get that examination?
We did not. We spent the better part of the summer briefing that issue back and forth, issues like how many psychiatrists for the government are going to be able to do that, what's going to be the setting, what kind of questions can they ask. That briefing continued throughout the summer and into the start of jury selection. We were still arguing about it when Kaczynski finally indicated he simply wasn't going to submit to a mental examination. Then the briefing switched from, well, what's the consequence of that refusal? And the government's position was there are all sorts of sanctions that could be imposed, including preventing him from raising a mental defense or barring expert testimony or variations on the theme.
Quinn, the notice that Steve has referred to was a 12.2B notice.
Correct.
Why did you give such a notice of intent to use a mental defense?
Well, first of all, let me just, I want to clarify something. That is a notice that you're going to present a mental defense through expert witnesses in the guilt phase. Or you're going to present that kind of evidence. And it really recently been amended to say if you're going to rely on your experts who've talked to the defendant, then the prosecution has a right to have someone talk to him too. So that was the setting for that. Our thought was that the jury was going to hear everything, as I say, about the offenses throughout the guilt phase, which is going to be quite prolonged. I mean, the government was going all out with all their evidence, although I don't know they needed it all, but that was going to be their decision. And then we were going to come in suddenly and say, oh, by the way, and here's Ted Kaczynski, you ought to know something about him. So we thought it was important that they get an early sense about who Ted was and his history and his mental illness. And so we wanted to present that evidence, not with any hope that it would defeat the convictions, but that it would at least introduce those kind of thoughts to the jury before we made a fuller presentation.
Did you intend to call experts on his mental condition during the guilt phase?
We originally did.
And what changed your mind?
What changed our mind, well, actually, what changed our mind was, first of all, there was a point where Ted became very upset about that idea, and was very upset about it. And we had some conferences in camera with Judge Burrell and developed it a lot. And we finally agreed that we would not present those witnesses in the guilt phase, expert witnesses. But we kept open the fact that we would present other witnesses and physical evidence like the cabin in the guilt phase, and both expert and other evidence in the penalty phase.
All right.
So that's essentially where it was at the time.
Let's get to the trial. How difficult was it to select a jury, Steve?
We called in about 600 people in the jury pool for the reason that there wasn't anybody who wasn't going to know about this case. And so they filled out about a 100-page questionnaire. And the procedure that the judge had set up was to call 6 jurors in the morning, 6 jurors in the afternoon. Each side would be given approximately 15 minutes to voir dire each of the jurors. So that's a half an hour times 6 jurors. We get 3 hours in the morning, 3 hours in the afternoon. And the jury has to be death qualified, so they have to be examined as to whether they have any serious objections to the death penalty, and things like that. And it was obviously a challenge to find people who had not already formed an opinion about the case.
Wasn't part of these proceedings actually conducted out at the State Fairgrounds at Cal Expo?
The initial 600-person jury pool was brought out to Cal Expo to fill out the questionnaires.
How long did it take to actually get a panel?
I believe, I just looked at this the other day. To my surprise, it only took 16 days. But that went from November, I think 12th is when we started, and we impaneled the jury a couple of days before Christmas.
After you finally got a jury selected, did anything unusual happen?
Oh, yes. Quinn has already referenced the fact that Ted had tried to fire his attorneys or express some dissatisfaction with their pursuing a mental defense. The trial was set to begin January 5th, and the court had thought, I think justifiably, that he had brokered a deal with Kaczynski to keep the attorneys on if they would agree not to present a mental defense. And Quinn can tell the story better than I can, but Judy Clark apparently premiered her opening statement to Kaczynski the night before trial was set to commence, so January 4th. And he was very upset, allegedly, about her mentioning mental issues in her opening statement.
Well, if Quinn can tell it better, let's
Yeah.
hear it.
Yeah, I'll deal with it allegedly, maybe.
Yeah.
Let me go back to jury selection, because I think there was one of the things that's very interesting about that was the big question for us was not whether people thought Ted was guilty or not. It was how could they keep an open mind on the 2 penalties. And so we spent a lot of time, both sides, asking those questions. And early on, what Judge Burrell did, as Steve explains, we would have 15 minutes each for 3 jurors, morning and at, and then we would get a transcript that night of the voir dire, and then we could make challenges for cause the next day, and so that we would deal with just kind of systematically like that, which I think was a very good way to do it. But it was early on in the voir dire, and I think Judge Burrell does not remember this. I was sitting there, and we would voir dire some of these jurors, and we would say, now, do you believe that someone intentionally kills someone, they should get the death penalty? And they say, oh, yeah. You know, and we're like, okay, we got a cause problem here. The judge would say, as judges always do in this thing, to make sure that you understand what they're saying, would say, but if I told you that the law required you to consider both penalties, would you consider it? The jurors would all say, well, yeah. So there would go the cause challenge, potentially. I mean, the judge could look at it. But I had realized that the jurors are sitting about as far closer than we are right now, below Judge Burrell, who's quite big, he's got a deep voice, and he would ask that question in a way that wasn't meant to intimidate them, but it was to impress them with what, you know, if I tell you this, you're going to do it. And I realized this is not going to work. I mean, everybody's going to say, sure, Judge, whatever you say, I don't want to get in trouble. I'll follow the law, whatever it is. And we want them to be honest about, well, where are you coming from on this? I mean, that's the key thing. So I had the temerity or rashness to say, Judge, could we approach you for a bench conference? And he said, fine. Went up there and I explained the problem as I saw it. And he said, well, I don't mean to intimidate him or, influence him. And I said, well, I understand that. I'm not saying that. I'm saying it has the same effect. And then he said, well, how about if I came down to the lectern where the lawyers stand when I ask my questions and ask the same questions, all that. And that's what he did for the rest of the selection. And I don't think it's ever been done before. I thought in the end the jury selection went very well. I'm not sure I was happy with the jury or Steve was, but I think given the pools and everything, it went very well. But I that kind of stood out to me. I don't know if anybody's ever done it before, but it just changed the dynamics. You know, when he was over further away and everything, I think people felt easier to kind of say what they were really thinking.
All right, now
So I don't know so that's my diversion. What was your question? Okay.
what happened when Judy Clark went over her opening statement with
Yeah.
Ted Kaczynski?
Well, you have to understand, first of all, that Ted is a diagnosed paranoid schizophrenic. He has written forever about the evils of mental health professionals and what they do in the way of mind control. He is a genius, and his core is his mind and his brain and his thinking. And the idea that someone would say that he had mental health problems was anathema to him. It would be like stabbing him, right? So he didn't want that at all. I mean, that is not something in public to have that. And he also felt that it would denigrate from the ideas in the manifesto, which I would recommend you read. It's about 30 pages. And it's really quite good, and it's not violent. It's not, it's not like it is his views about what technology will do to our society. Sound a lot better now than they did back in '97 or '96, and also about mind control and those kinds of problems. So when he had agreed to this arrangement, first of all, the big thing that it came up early on was, who makes the decision as to what defense is put on when the person is represented by counsel? Our position was, it was clear you cannot, there are certain things that a defendant with counsel decides for themselves. One of them is what plea to make. They also decide whether there be an insanity plea, because that in effect is a plea of guilty and by reason of insanity. One reason that was not raised here. Whether they'll take the stand, whether they'll address the judge. There's 4 of them or 5 of them. Our position was that, and we thought the case law supported it, was other than that, it's up to the attorneys to determine how to proceed in support of the not guilty plea. And we thought the law supported that, and I think it did, but it wasn't by the U.S. Supreme Court or something like that. Judge Burrell agreed on that, and so it was understood that as long as we were his lawyers, we would decide what witnesses to call, how to pick the jury, how to do all the things that lawyers do. So early on, then there was this broker deal when he was upset again about the idea of his mental health coming in, that we would drop the experts from the guilt phase. Later on, we would have to drop the experts even from the penalty phase because he refused to see the government psychiatrist, and the sanction would have been we couldn't present our experts in either phase. The reason he didn't want to see the government psychiatrist was he was afraid, hard to believe, that the government psychiatrist, Park Dietz, would find him mentally ill, his big fear. But in any case, he did not want us to put on that testimony about, and what we were going to do is we were going to try to explain his mental illness through other evidence, his lifestyle, where he had started from, where he had gone to, how he had ended up being a whiz kid who skipped 2 years in high school, went to Harvard on a scholarship, got a PhD in no time from Michigan, and then ended up living in this cabin and this kind of crazy life. In fact, we brought the cabin down from Montana. We stored it out at the Air Force Base. We were going to have the jury go see it. I mean, you could not imagine this. Calling it a cabin sounds like it's going to be an A-frame. This was, as Steve says, like a 10 by 8, 2 windows about that big, a big pot stove there, no running water, no toilet. I mean, it was more like a cell than anything else. And for him to voluntarily go there, we thought would help them understand his mental problems, which I think fed his schizophrenia. You know, you're sitting there in the dark in February in Montana from 3 until 10 in the morning, with no electricity and everything. But we wanted to put that on. He did not want that. So there was some back and forth on it in meetings and attempts to see if there was some way we could fulfill our obligation to try to save his life, and he would be satisfied with that. And there was even talk about another attorney coming in, Kevin Climo, who was an experienced defense attorney here, came in to counsel Ted and give him advice on this, independent of us, where we were involved. And in the end, he declared, after some backs and forths and everything that Steve couldn't believe these things seemed like it was resolved, it's not resolved. He decided that he wanted to represent himself. He declared what they call a Feretta right. It's a case, Feretta versus California, that says you can represent yourself in a criminal trial. Do you want me to carry it from there, or should we stop at that point?
In context, this takes place after the jury selection.
Correct.
And after he's had this discussion with Judy Clark, telling him what she plans to say in her opening statement.
Right. That's what triggers his first concern in addressing the judge about it. There's some further proceedings. He seems to be mollified with some other changes that were made. He expresses his concern again, and then finally, I think maybe on the 3rd time, he says, I want to represent myself. I'm asking to do it, which is the Feretta request. At that point, Judy and I felt that we had to declare a reasonable doubt about his competency to make that decision. And then usually if the lawyers declare that, and there's some basis for it, and we certainly had no basis for it, then the judge will order an evaluation of the defendant, and then we'll hold a competency hearing and decide for himself whether the person is competent or not. And that's what happened here.
And what did Judge Burrell rule?
Well, the first thing happened was he agreed that Ted had to be examined and evaluated for his competency. And it was agreed after some back and forth between the government and the defense that rather than send him off to some federal medical center, and because of the time problems with the jury coming in, we would ask to have someone come out and evaluate him. And the government arranged, or actually it may have been Judge Burrell, arranged for Dr. Sally Johnson, who was the chief of the federal medical complex in Butner, South Carolina, and who had handled a lot of these cases, competency cases, including Hinckley and other ones, to come out here, look into the case, read whatever she needed, talk to Ted, and make a decision as to his competency. And it must have taken 4 or 5 days. She got out here and did all that, and she heard from the government, she heard from us. She came back with a report that said that he was a paranoid schizophrenic, but she did not feel that he was, because of that, he was unable to assist his lawyers in his defense. That's the standard for competency. And therefore, that he was competent to make the decision to represent himself. Then the question was whether Judge Burrell would grant that motion, that Feretta motion. And the judge denied it on 2 grounds. One was that it was untimely because it should have been made before the jury had been impaneled. And secondly, that it was being made for purposes of delay. I think that's the word.
Yeah.
And therefore said that you cannot represent yourself. You're going to stay with these attorneys. And then I can talk about what happened after that, or if you want to see what Steve has to say.
I would like to see what Steve has to say. What did the government think of Judge Burrell's rulings on those issues?
This was a snake pit. This was terra incognita. We were dealing with issues that were very fact-bound, and the government was flying in the blind to a certain extent because a lot of these hearings had been conducted in camera, so as they should have been. And so we didn't know exactly what was taking place. We were concerned about the Ferretta issue because if anything is going to get you reversed, it's going to be an issue like Ferretta, which involves a defendant's constitutional right. And we were concerned about the findings that it was for purposes of delay, bearing in mind that Kaczynski had first raised concerns as early as November 25th. The judge very meticulously went back and looked at the jury selection proceedings and determined, picked apart the record and determined that Kaczynski must have known at that early stage that that there was a mental defense, and so that was the basis for the judge's conclusion that his later request to represent himself, which occurred, I think must have been 6 weeks later, was untimely, and that what he was presently engaged in was for purposes of delay. We didn't see it necessarily that way. I felt that Kaczynski, being a layperson, was wrapped up in issues that he was only gradually coming to understand. And Judge Burrell did address those issues, and whether or not a layperson would be expected to know how these things are unfolding. So he was not unaware of the issue either, but from our standpoint, we were very concerned that that was a live issue.
How did that issue or that concern affect your desire to continue to go ahead and seek the death penalty?
Well, we were fully prepared to start trial on January 5th, and then afterwards, the next day, January 22nd, I think, when all the proceedings were finished, we were fully prepared to go forward with the trial. We had some discussions with the defense in December, I believe it was, and they made some demands which we couldn't accede to. So those discussions were cut off.
Right. Quinn, what happened next?
Well, I think you have to go back to what happened in December. I'm not sure the timing of it, but we approached we went back to Washington again and presented further mitigation evidence to the Capitol Review Committee, whatever they're called, asking them to remove the death penalty from the case, and they declined to do so. We then approached later in the fall, maybe December is right. We approached the local prosecutors, Steve and his team, to see if they would entertain an offer to plead guilty and remove the death penalty with 2 conditions. One condition would be, normally if you plead guilty, you waive your right to challenge rulings, like the suppression motion. We wanted to be able to preserve the right to appeal the suppression motion, which there's a procedure for doing, but the government has to agree to it. And at the time, we wanted to know whether they would agree that he would not be sent to a mental institution, and as opposed to any other place Bureau of Prisons had under its control, or Department of Justice, and they declined to do that.
All right. So what happened after the?
Well, what happened afterward then is So we're on about maybe the 22nd of January. Ted has been found, been mentally ill but competent. He has also been denied his right to represent himself. So he has us as his lawyers. He knows what we're going to put on in terms of evidence in order to try to save his life. And at that time, right after Judge Burrell's ruling, I approached the bench and said we wanted to plead guilty to all the crimes here and New Jersey for no death penalty and without those other two conditions.
And the government accepted that?
We did.
Did you have to consult with the Attorney General?
Yes, we did, and she gave her approval.
What were some of the considerations?
I had had some discussions with the Solicitor General in the interim about the twin rulings that we've been talking about, the denial of the Ferretta request and the ruling that Kaczynski was not in charge of his own defense. We discussed that with the Solicitor General. We acknowledged that there wasn't very much case law on it and that we're dealing with really some very cutting-edge issues. The Solicitor General indicated that he thought that there was litigation risk there, that if we went through with the entire trial, it's possible it could be reversed, and we communicated that fact to the Attorney General. The Attorney General received that information as well as other information. She'd already been apprised, of course, of the December negotiations regarding their offer to plead. So it's not like she wasn't prepared to receive that type of offer now.
How many bombings did he plead guilty to?
Well, he pled to all 5 of the charged bombings, including the one that was charged in New Jersey. But we took a factual basis to all 16 of the bombs, so he admitted to all 16.
In the Rule 11 proceedings, the judge usually asks the defendant some questions. When the judge asked him his occupation, do you recall what his answer was?
He said something, I suppose I'm an inmate, something like that?
Yes, prison inmate.
Yes.
What sentence did he receive?
4 consecutive life sentences.
As a epilogue, what happened to the land upon which the cabin was situated?
A couple years after the criminal proceedings came to a conclusion, a woman stepped forward asking to purchase the land. Unlike other possessions, pretty much you have to sell the land to somebody. It can't just sit there titleless. So we did some investigation of her and finally decided that we would not stand in the way of that purchase, and Judge Hollows signed off on the purchase of the 1 1/4 acre parcel that the cabin sat on.
What happened to the cabin itself?
The cabin remained at Mather Air Force Base for a number of years. I think just recently, in the last couple of years, maybe 5 years, was transported to the museum in Washington, D.C., which is where it is now.
Actually, I think it went to the FBI, took it, and then held it for a while, and then
Right.
and then moved it to the museum as part of an exhibit there about this case.
How about all the contents of the cabin? What happened to them?
Well, after a bunch of litigation, there was an order made that the contents should be sold by the marshals and the proceeds should be given to the victims as part of the in payment of restitution.
That essentially closes the book. We're running a little late, but I want to ask each of our panelists if they could close with a 1 or 2 minute statement about what you learned as a result of this whole experience and what it means to you. Terry?
Thank you, Judge. I learned and had reiterated a lesson that there's no way, whether it's the FBI, federal, state, local agency, that we could ever come close to solving these kinds of crimes, especially the ones involving lone actors, without help from the public. And I think many times when you look at how something comes together, you don't realize that in many of these, in fact, recent terrorist cases, cases where or acts of terror where they're prevented by someone alert in the public deciding to do something about it and take the information they have or their observation of someone and in many other instances, the case is solved and people are arrested. It takes tremendous courage and conviction and decency to come forward and then to begin the work with us of trying to pull things together. And when I look back at this and I think of all those qualities that David possessed, people such as the victims who, like Gary, who were always constantly there for us even and showed such great courage with all the things that had happened to them. I think it touches you deeply. It makes you realize why you got involved in law enforcement. But it serves as a constant reminder that we have to go to the public and give them as much as we can give them so that we can use their support and their help to find out how to bring these cases to a conclusion.
Gary?
Yeah, that's, I'd probably talk about that for a long time, but squeezing that into a couple minutes, I guess a couple of things I learned would be that I don't think anybody knows what they're going to do with something like this until you're actually in it. You learn a lot about that, a lot about yourself, a lot about people. You learn a lot about the people sitting at this table, lots and lots of people that I dealt with through a lot of years, especially not knowing for 9 years who it was. A lot of friendships developed on all sides of law enforcement and prosecution, defense. I have a lot of friends that way. Kind of echoing a little bit what Terry said, I felt like it was my job to get out and do what I could as a victim, if you will, because I don't really like that word as a judge had mentioned. I'm a survivor. Paris Hilton's a victim. So just thought I'd put that out there. But yeah, in my world, I mean, I was approached to go out and do things like Unsolved Mysteries, America's Most Wanted, things like that where it had never been done, and there's a certain amount of risk that goes with that. I mean, whether or not somebody's coming back at you or not. But that's the way, in my world, things worked. My dad was a state trooper, so I grew up that way. So I just really more or less appreciated a lot around the system. I appreciated what it offered me, and the ability that I actually had a voice. So when you are in the middle of that, I think it's, well, in my world, the job to get up and say you have a voice. So I continue to do that.
Thank you. Quinn? Oh, excuse me, Steve.
I was going to say.
All right. Well, I don't know if these are great insights or anything, but I came away from the experience with a couple of thoughts. One is, and I think Terry would agree with this entirely, you have to constantly re-examine your assumptions. There were so many false leads in this case. Instances where we thought we had the Unabomber on the line. This has to be the guy. There are coincidences that just can't be explained away, and they were explained away. And so constantly, when I hold that with me, whenever I was conducting investigations after that, I would continue to re-examine the assumptions. The other one has nothing to do with law. It has more to do with the fickleness of fate. There were several of these instances that could easily have resulted in the death of more individuals. Gil Murray, the victim of bomb number 16, which occurred just about 5 blocks from this building. The package was delivered in a big, one of those white mail tubs to the business. The bomb was actually sitting on top. The mail was late that day. So all the employees of the Timber Association were kind of congregating around the reception area to get their mail. Gil Murray was called out to receive his package, which actually wasn't even addressed to him. It was addressed to the prior president. It was a very tightly wrapped package with brown packing paper. It was designed to detonate when the tension on that packing paper was released. So if you just release the tape, that's enough to explode the device. FBI still doesn't know how that was possible. In any event, Gil Murray comes out. There are about 8 people standing around the counter, leafing through their mail, having discussions, when Gil Murray is trying to open this package. He's having difficulty because it's so tightly wrapped. He can't do it with his fingers, so he asks the receptionist for a pair of scissors. As this is going on, one by one, people are filtering away. One person gets a phone call, has to go back to his office. Another person calls a coworker aside to the hallway to talk about some point. Other people are simply getting their mail and going back. As the receptionist is handing the scissors to Gil Murray, she gets a phone call. The caller wants to know the number of another person. It's not on the Rolodex at the reception desk. The receptionist, who's just filling in for the real receptionist for the lunch hour, puts the caller on hold, goes back to her office to retrieve the information. She gets about 10 steps outside the hall when the bomb explodes. Gil Murray's the only one killed because he's the only one left in the reception area at that time. Had the bomb exploded 30 seconds earlier, there probably would have been a half a dozen fatalities. The same story repeats itself with Thomas Mosier, the victim of Bomb 15. His wife and daughter, 1.5-year-old daughter, I think, come into the kitchen just as he's starting to open the package. The daughter needs a diaper change. The wife does a 180, leaves the area, goes back to do the diaper change. The bomb explodes, and Thomas Mosier is killed instantly. There are other examples of that, but I just hold on to that thought that, as they say, but for the grace of God, we could have had a lot more fatalities.
Thank you.
Excuse me. I guess what I take away from it is a great admiration and respect for David Kaczynski. He and his mom were estranged from Ted because of Ted's mental illness, but they were very supportive of him. And when actually I think as Gary says, it was David's wife who really started saying, "Could that be Ted?" And then when he realized he thought it could be, and he was just torn between this. On the one hand, this is my brother, and if I turn him in, what will they do to him? On the other hand, if I don't, and he's really the Unabomber, will more people be killed? And he went through that horrible back and forth, and then with the help of this wonderful lawyer from Washington D.C., Tony Bisegli, came forward, and it was the key to this case. I don't know if the task force would have got there sooner or later, but it would have been a while, I think. And David was given a reward, $1 million, I think, and he dedicated it to helping other victims. He was going to use it solely for that. He and Gary, who Gary could speak about more, have become friends, I think, is certainly a fair statement.
Yeah.
And they have gone together to talk to victims groups and to, Gary can speak for more of that, but he's continued in that area, in the death penalty area, and he also has come together with the brother of a fellow by the name of Manny Babbitt, who was a California state capital defendant, and the brother of Manny Babbitt turned him in, and the state executed him. So the two of them go around and talk about victims and responsibility. So I just think they're wonderful, and I think Gary's wonderful. He's been much more forgiving, whatever words, than I ever would have been.
Thank you, Quin.
Thank you. This concludes the presentation. We want to invite all of you to attend the reception in the Anthony M. Kennedy Learning Center downstairs, where there will not only be refreshments, but the panelists will be available to talk with you, answer any questions that you might have. And there is an exhibit there of photographs and evidence that would have been used at the trial of the United States versus Theodore Kaczynski, had that trial actually gone forward. Thank you very much.
About an hour and 50 minutes.
Yes.